May it please you, my lady, Mr. Toko and I appear for the applicants. And together with Mr. Richard Spoor.
May it please you, my lady, we appear for the first to fourth respondents. That is the state respondents, assisted by Ms. Grikas.
May I please the court, I appear for the fifth respondent together with Mr. Mark Caruso.
My lady, just on a couple of housekeeping issues. My attorney, Mr. Spoor, has asked for permission to address an aspect of the court, which is the alternative argument on compensation. I hope there will be no difficulty from any of our, yes, it looks like there's no difficulty from any of our learned friends. Yes, thank you. Could I then give an outline of what we're going to do this morning? We have discussed with both the state and the mining company the question of the division of time. What we hope, that they are not in contention, but they are important insofar as they ground the argument of the applicant. The second point is to illustrate the four grounds on which we say we are entitled to the declaratory relief that we seek. The first ground being the Interim Protection of Informal Land Rights Act 31 of 1996. The second substantive argument being the government policy passed pursuant to the provisions of IPILRA, which we say is still binding on the state, and the manner in which this mining right has been dealt with infringes the terms of that policy. And the third argument being the customary law argument, where we contend that any scheme that entitles the state to grant a mining right under Section 23 without the consent of the community is an infringement of the customary rights of the community, which are specifically provided for in Section 211 and 212 of the Constitution. And then the final cause of action is international law. So we shall illustrate that by reference to Section 39(2) of the Constitution, the court is under a duty to follow international law, not only as a matter of interpretation, but also as a matter of substantive entitlement of indigenous communities, such as my client. And then finally, I will respond to some of the MPRDA arguments that have been proffered by the state. And the key point to be illustrated around the MPRDA is that the MPRDA is not an ouster to provisions like IPILRA. In fact, on a proper construction, the intention of the legislature is that IPILRA must be read to complement the provisions of the MPRDA. So whilst the MPRDA might set a baseline minimum consultation requirements, it does not set the ceiling, and other statutes might fill other gaps that are not dealt with by MPRDA directly. So having said that, could I just start off by sketching some background facts to the case? And I do not wish to take a lot of time because most of these facts are common cause because they are not disputed. So firstly, what area are we talking about? And the actual geographic sketch of the area, the court will find this in page 91. And that's the area that will be affected by this mining. And this comes from the application for the mining right itself. And it is annexed DB3. And the court will see from the outline of the map that that is the coastal area, and it's specifically sketched as residence locations, rivers, and the mining block. And the mining block, the court will see, is actually a block comprising of virtually all of the residence locations and the rivers. So that's the area that we are dealing with. It is in the Transkei coastal area known as the Wild Coast. What the facts show is that on the residential side, it comprises between 70 to 75 homesteads. These are, in the papers we use the Xhosa word for it, which is imizi. But there are 70 to 75 of these homesteads. And there are approximately individuals, 600 of them, living in these properties. And more than half of these individuals are adults, and slightly less than half are children. We, as the applicants, there are 128 adult applicants that have brought these applications. They represent 68 of these homesteads, so 68 out of a possible 75. And that shows 90% of all of the homesteads in the affected area are before court today, raising the arguments about consent. And the actual application itself, the court will find that at Annexure DB4, at pages 92 to 296, it takes up a lot of time and a lot of space. But nothing much turns on the content of the mining right application, because this case, of course, is a conceptual case about the interface between the MPRDA and the repeal law. So, what the fifth respondent did in its application to mine, and this is now, the leadership will recall that there was a 2008 application, but we are concerned here with the 2015 application. What it proposes to do is to mine 2,859 hectares. And that is the portion that we've referred to at page 91, which is the mining block. And if you go back to page 91, you will see that that mining block basically takes up the entire space that is currently occupied by my clients. And so it is not only the mining, but it is also the mining inclusive of its activities that will impact on my clients. So now that we know the actual geographic area, the second aspect to cover relates to the impact of the mining. This is covered in paragraphs 154 to 156 of the founding affidavit. In other words, when they start the mining, what effect will this have on the livelihood of these communities? So we've dealt with this in full at page 48, 49, and 40, 50 and 51. And in summary, what my clients contend will be the consequence of the mining operations is physical displacement from the homes that we've looked at page 91, economic displacement, loss of access to the land, loss of access to grazing rights, loss of access to water. And the leadership would have noted at page 91 the river streams that run through the villages. Influx of new people into the area, the destruction of the cultural life of the community, and generally loss of access to the property. Because what is common cause is that the consequence of the move of this mining company will be that the community must physically be relocated from the spaces that they currently occupy. On the cultural side, what my clients have contended in the founding affidavit is that their graves are also located within the proposed mining area. And so even if the graves themselves will not be relocated, the point is that the connection between my clients and their graves will be disrupted by the impact of the mining. What my clients have also contended in the founding affidavit is that if one has regard to the contents of the mining right application itself, what it fails to address, and this is what we deal with at paragraph 158 at page 52 of the papers, what the mining right application does not address is which homesteads will be resettled, who will move and who will not move, what will be the terms of the resettlement, what alternative land will be made available in the event of the resettlement, what measures will the mine take to restore the livelihoods that will be disrupted as a consequence of the physical relocation? And how will compensation be dealt with in the event that dislocation and relocation are unavoidable? And when the mine was confronted with this allegation, which is, you've put in an application, but you haven't addressed those things that matter to us, it responded to this at page 1362. And your leadership will see the responses at paragraph 25.1 and 25.2. This is what the mine says. It says the allegations in this paragraph repeat allegations made in the objection by the ACC. The ACC is the Amadiba Crisis Committee that I referred to in paragraph 9 above. Transworld will deal with these allegations in the mining right application process. They are not relevant to the current application, and it suffices for me to deny that Transworld's application is defective for any of the reasons given in this paragraph. For purposes of the legal issue that the applicants seek to test in this application, I've been advised that it is sufficient for the applicants to establish that the proposed mining operation will restrict any informal right to land that they may currently possess that entails access to, occupation, and use of the land in the proposed mining area. Transworld does not dispute this. Now, it's that common cause that the impacts that are described by the applicants, the disruption of their lives, will eventuate even on the version of the mining company itself. It accepts that my client's access to the land will be denied, my client's use of the land will be denied, and my client's occupation of the land will be denied. Of course, their point about relevance is misconceived, because this is a case about consultation versus consent. It is impossible to envisage a world where my clients can participate meaningfully in the consultation that is envisaged, or for that matter, can provide their consent without the basic facts that are outlined in the founding affidavit at paragraph 158. My clients have been denied knowledge about the plans about relocation in circumstances where it is common cause that they will be physically dislocated, physically displaced from their property. And hence, it is impossible for them to exercise a free, prior, and informed participation in the consultation process. So the mine is wrong when it alleges that the facts that we say have not been disclosed in the mining right application are not relevant. They are clearly relevant because they give meaning to the question of the substantive rationality of the consultation process. Without the knowledge about the plans of how to restore the lives that will be disrupted by the mining operation, it is impossible for my clients to give their consent, and it is impossible for them to participate meaningfully in the consultation process. Beyond what my clients envisage is likely to happen if the mine continues is an affidavit by John Pepper, who is a representative of a company, an NGO called Benchmark Foundation. And this appears at page 512 of the papers. Uh, 511, I apologize. This is an affidavit of some importance because we know what my client's concerns are in relation to the impact of the mining. But John Capel has given evidence of an expert nature, because what he has been able to do, and the affidavit is 512 to 540, what he has been able to do is to conduct an in-depth study of the impacts of mining on the platinum side, but also across the country as a whole. And he thoroughly dismisses the assumption that the benefits of mining always outweigh its negative consequences. And he comes to the conclusions that it is not always the case that because there is this supposed broader public good, therefore the concerns of the community can simply be overlooked. And also what he makes quite clear is that often people assume that mining will bring about employment, but the experiences of the local communities on the mines that he has surveyed shows that this is often an illusion. What in fact happens is that there are greater negative consequences from the point of view of pollution, whether it is water pollution or air pollution. There are negative social consequences because of the influx of new people into spaces that were otherwise run according to tribal or community life. And that itself has negative health consequences, negative social consequences. And so mining, according to John Caper, we should not always assume is good for the community. In fact, often, from his experience, mining produces regrettable consequences for the communities directly affected by mining. I've raised the point about paragraph 158 of the founding affidavit and compared it with the affidavit by John Caper. None of those are disputed at all. So your leadership can accept that insofar as this specific community is concerned, mining will bring about physical dislocation. No meaningful answers have been given by the mine to the contentions made by the community. On an expert level, John Caper has shown that mining across the Platinum Belt has in fact disrupted social lives without any discernible public benefit to the specific communities that are affected. All of these are useful information because, as you would have noted from the affidavit of John Caper, especially on page 512, when he talks about even if people are not physically relocated, the effect of the blasting of those mining operations sometimes results in the cracking of houses. There are in fact low levels of employment at the local level. There is in fact a high level of dust that results in air pollution. There is an increase in squatter settlements, so-called informal settlements. There is sometimes an increase in the levels of HIV consequent upon the influx. And then, of course, the loss of land is almost inevitable. And then the final point where he makes the point that actually it is not always clear what the benefit is. And you will see all of those made at page 517. So that's the context of the current application. And that is why our clients are specifically concerned about what will happen once this mining right application is granted. Now, of course, the government has not granted the mining right at this stage under Section 23. But that's largely no longer a stumbling block to this court adjudicating the case, because whether it grants the application or it does not grant the application, the legal question whether or not my clients are entitled not only to be consulted but to consent will remain. So this is in fact the appropriate time to resolve that issue once and for all. And it will also inform the further conduct of the government. It will inform the attitude of the government. The leadership would have seen from the papers that there was a point when the government did not believe that consent by my clients was necessary. And they were working on the assumption that a mere consultation without more would suffice. But a judgment by this court will guide not only the government, but it will also guide the mining company in relation to how it should deal with my clients. Now, on that very point, we can now move on to the status of the current mining right application. And some aspects of this are also relevant, and they need to be unearthed. Firstly, my clients suggest that they were not aware of the mining right application. They became aware of it for the first time on the 8th of April, 2015. And the circumstances under which they became aware of this was when Mr. Peter Badenhorst, who is the environmental specialist of the mining company, addressed a community meeting. And in that meeting, Mr. Badenhorst did not in fact tell them about how the mine proposes to address the concerns that would come about as a consequence of this mining operation. And that meeting, my client suggests, was facilitated by the local chief, Mr. Lungabaleni. And this becomes a crucial point in the narrative because the expert employed by the government, Professor Mpege, now suggests that actually the participation that's required is the participation of the traditional authority. And let's look at the role of Mr. Lungabaleni to contextualize the participation of the traditional authority as opposed to community consent. What we know from the affidavit of Mr. Baleni himself, and it is at page 276, and it's annexed as DB10, is that Mr. Lungabaleni was once an opponent of mining. But certain facts that are described in his affidavit at page 276 made him change his mind. And the leadership will see that affidavit 276 to 277. At paragraph 4 of page 276, this is what Mr. Baleni said. It says, in 2012, before I knew that I was successful in defending my chieftaincy, I was approached by Mr. Kunya. Mr. Kunya is the deponent on behalf of the fifth responder and other members of the Amadiba clan. They offered to withdraw the legal action against me in return for persuading the community to support the mining of titanium in Proceedings by Transworld Minerals. In particular, they asked me to appeal to those in the community who strongly oppose the mining to agree to it. Secondly, he says, I was also informed by Mr. Kunya that a Royal Trust family bank account would be created and that the chieftaincy would be entitled to 4% of the profits obtained by the titanium mining. I later discovered that they had been aware of my successful defense of the chieftaincy and had therefore created the above proposal with this knowledge and with the hopes of securing my support for the above-mentioned mining ventures. But beyond these two aspects in his affidavit, what has been said about Mr. Baleni in the founding affidavit is that he is now in use, at the time setting of the affidavit, he was in use of a vehicle provided for by the mining company. Not only was he in use of that vehicle, if you look at page 279, right up to page 303. That is information from the company registration office, which shows that the local chief of the area is a director of the fifth respondent and is also a director of its BEE partner, Olco. So your leadership can draw your own inference about these facts, but these are facts that are undisputed. So what we know about the standpoint taken by Professor Mpege, if it can be placed in its factual context, is that the local chief is a director of the mining company, he is a director of the BEE partner, he has a car given for him by the mining company, he effectively was persuaded to withdraw, to persuade the community because of his offer to withdraw in opposition to his chieftaincy. And the fifth thing that we know about him is that he was promised 4% of the share in profits in the mining venture. So, not only have my clients not been taken seriously by the government, they have not been taken seriously by the mining company. And the local chief has also been directly conflicted in relation to the way in which this matter was dealt with. And so that is why they ask that they are the people who must give the consent. And what we also know about the facts of this case, and these are also undisputed allegations, is that there is a conflict in the area, an ongoing conflict. There have been assaults, there has been an interdict granted, there have been personal threats. This, the leadership will see from paragraphs 188 to 189, right up to the end of December 2015. So, if we know all of these facts, now we can see why my clients are specifically concerned. And it is not enough to speak to the government, it is not enough to speak to the local chief. As the people most directly affected, the consultation and the consent must take place through the structures of the community. We have set out in our affidavit the living customary law of the Amapon. What that living customary law illustrates is that there is a multi-layered system of community consent, consensus, conciliation in relation to the use of land. It is true, as the government has suggested in its heads of argument, that this is not a case, well, it is a case in part about mining, but our case is a case about the usage of land. Once one has regard to page 91 and sees that actually this mining operation is not about the exploitation only of the mineral, but it is also about the usage of the surface lands, then it's quite clear that the laws that apply in relation to the usage of land will be taken into consideration. Could I then move to the first cause of action, which is IPIRA? So what we know about, I wonder if your leadership has a copy of the Act. I've got a copy here that I'm happy to have. So we start off with section 25(6) of the Constitution. That section, your leadership will recall, is located under the property, so-called property clause. But section 25(6) provides that a person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws or practices is entitled, to the extent provided by an Act of Parliament, either to tenure which is legally secure or to comparable redress. The IPIRA, we have contended, was one of the statutes passed during the period of the transition in 1996 to give effect to a constitutional right which entitles people and communities whose tenure to land was not secure to statutorily protected security of tenure. On the current facts, it's quite clear that my community, the clients that I represent, fit the description of a community who did not have security of tenure as a result of past racially discriminatory laws. The affidavit of Professor Baynard, which largely is undisputed, takes the story from 1894, when Cecil John Rhodes passed the proclamation to annex Pondoland. And it includes the Glen Grey Act that was passed in the Eastern Cape. And it takes the story right throughout apartheid and shows that in relation to the Pondoland area, the rights of access to land always resided with the communities. And that although the government tried various measures to undermine the security of tenure, it never ultimately took ownership of the land as such. So the effective mode of ownership remained a form of customary ownership. Even Professor Mqeke, who responds to Professor Baynard, simply confirms why my clients had insecure tenure, because he refers to proclamations passed in 1966 and 1968, And the effect of those proclamations was to locate the focus of power to the chiefs in relation to land administration as opposed to the communities. And of course, we know in the 60s, and this is a story narrated by Professor Bynum, that the Pondo revolt was a consequence of a response by the Pondo people against what was called a betterment policy. And that betterment policy was to concentrate native people into small locations outside of their land. So it is plain on the fact that my clients fit the description of a community whose tenure to land was vulnerable as a consequence of past racially discriminatory practices. So IPILRA was a response by the democratic government to ensure that there is security of tenure in respect of communities like my client. And it is so that IPILRA was intended to apply on an interim basis. At the time it was passed, it was intended to apply until the end of 1997, so until the middle of 1997. But the minister was given authority to extend the operation of the Act. As we speak, in the past 21 years, the Act has been extended. As matters stand, it's been extended until the end of 2018. So it remains in the statute books and it remains operative, and therefore its provisions should be given effect. So the first important substantive element of IPILRA is the definition of an informal right to land that your ladyship will find in section 1 of the Act. It has three components what an informal right to land is. The first is use, occupation, or access to land. We know by reference to page 91 and by reference to the founding affidavit and by reference to what the mine has stated that the use, occupation, or access to land will be disrupted by the mining operations. And so an informal right to land includes use, occupation, or access in terms of tribal, customary, or indigenous law or practice of the tribe. And then sub 2, the custom, usage, or administrative practice in an area or community where the land in question at any time vested and BB is in the government. So it's clear that under section 1A of IPILRA, we have informal rights to the land flowing from tribal, customary, or indigenous law. And we also know that the custom usage in the particular area took place through the scheme that is envisaged in AABB and CC, because there is a specific reference to the governments of the former republics of Transkei, Bophuthatswana, Venda, and Ciskei. And we know that my client fall within the governments of the Republic of the former Transkei. So, two things that need to be emphasized at this point. The one is that IPILRA gives effect to a constitutional right. The second is that my clients are the targeted group of the benefits of IPILRA. The next point then is what provisions exist. In other words, how did the government give effect to this protection? It did so by passing section 2 of IPILRA. Section 2 contains crucial provisions. The first is subsection 1. Subject to the provisions of subsection 4 and the provisions of the Expropriation Act or any other law which provides for the expropriation of land or rights in land, no person may be deprived of any informal right to land without his or her consent. So the consent requirement is specifically built into IPILRA, and it is only excluded if you follow the Expropriation Act or you follow any other law that allows for expropriation of land or rights in land. So from section 2.1, we don't have a statute similar to the APRDA because the APRDA is neither the Expropriation Act nor is it an act that allows for the expropriation of land. So for purposes of IPILRA section 2.1, our clients can only be deprived of their informal rights to land with their consent. Then sub 2 deals with the land held on a communal basis. Where land is held on a communal basis, a person may, subject to subsection 4, be deprived of such land or right in land in accordance with the custom and usage of that community. Now, this is an extra layer of protection. Firstly, you have consent. Secondly, you have compliance with custom. So the deprivation can only take place with consent, firstly, and it can only take place subject to compliance with the custom of that community. That explains why we have brought a specific prayer for declaratory relief based on custom. Now, there was initially a dispute in the pleadings around the question whether this would amount to a deprivation. In the heads of argument, that is no longer taken up. It's quite clear that the granting of the mining right will lead to deprivation. And we have shown by reference to page 91 that the entire mining area will have to be fundamentally reorganized if the consequences of this mining permit are to take effect. So we now know that there is a specific statutory protection around the circumstances in which deprivation can take place. We know that they have not consented, and we know that the customary system that we have dealt with confirms consensus as a basis for deprivation. And if your ladyship looks even in the affidavit of Professor Mteke, which is 1451, this is the expert of the government. 1451, that's where it starts. And at paragraph 1450, page 1454, paragraph 7, where Professor Mteke says the contents of paragraph 85 of Ms. Baleni's affidavit regarding customary law of Pondoland are based on wrong assumptions about customary law in general. But here is the important point. Conciliation and consensus in decision-making is common among the Nguni group, and therefore not peculiar to the customary practices in Pondoland. And then he refers to Hammond that took command of consensus, development of transfer local government. So, on either version, whether it is Baynard or Mteke, it's clear that the system of land administration is founded on consensus and consent. Could I then move to the next part about the MPRDA, which is the question whether the MPRDA amounts to an ouster or it overrides the provisions of the IPIRA. Now, we argue that the MPRDA did not have the effect of overriding IPIRA. It left the provisions of IPIRA intact, and therefore IPIRA continues to operate. We base the relief for a declarator on sections 22 and 23 of the MPRDA. Section 22, your leadership would have seen, describes the process of the application by a prospective mining operator. Section 23 describes the decision-making process by the state once it has received the application. So firstly, we say on the text, the MPRDA does not provide that any other laws that may impact on land are repealed. And in our heads of argument, paragraphs 108 and 110, we have dealt there with the presumption against implied repeal. So we say first, if the intention was to repeal IPIRA, which was known at the time the MPRDA was passed, that would have been explicitly stated. we have referred to two authorities, one by the Constitutional Court and the other by the Supreme Court of Appeal, that our constitutional jurisprudence works on the basis that laws must be read together unless there is a clear conflict between the two, and that one should not pursue a repeal by way of implication. A repeal of a statute passed by the legislature must be explicit. What then is the point about whether the two can be reconciled? IPILRA and the MPRDA do not clash. They do not provide for the same area in relation to irreconcilable provisions. What they do, they complement one another. They provide for different aspects. The entire purpose of the MPRDA is to regulate mining and the granting of mining rights. The entire purpose of the IPILRA is to regulate access to communal land. So their substantive purposes are different. But because mining inevitably takes place underground and therefore has an impact on the surface, IPILRA provides for protections to those people that are on the surface. Therefore, there is no conflict between the MPRDA and IPILRA. There is complementarity between the two. Quite apart from the fact that there is no textual conflict between IPILRA and the MPRDA, there is a constitutional requirement to read statutes so as not to produce a conflict. So if a conflict can be avoided by a reading of two statutes in a complementary fashion, that is a reading that must be preferred. This applies particularly so in an act like IPILRA, because it is an act specifically designed to give effect to a constitutional right. From paragraph 115 up until 126, we have dealt with the field, which we call covering the field. The field covered by the MPRDA and IPILRA. And we have tried to show that these two statutes cover different fields. I might at this point refer your ladyship to a judgment referred to in paragraph 119 and 120 of our heads of argument. And this is the Maxand judgment. Your ladyship will recall the facts of that case because they are the closest to what we are dealing with here. Because in Maxand, a mining permit, a mining right rather, under Section 23 had been issued, but the municipality refused to give effect to it without compliance with regulations and laws around land rezoning. And there was a debate as to whether or not the MPRDA would trump the local laws in relation to land usage at municipal level. And this is how Justice Jafta deals with the issue. And we've cited the passage in paragraph 119, where he says, if it is accepted, as it should be, that LUPO, which is the act in question here, regulates municipal land planning, and that, as a matter of fact, it applies to the land which is the subject matter of these proceedings, then it cannot be assumed that the mere granting of a mining right cancels out LUSO's application. There is nothing in the MPRDA suggesting that LUPO will cease to apply to land upon the granting of a mining right or permit. And then he continues, by contrast, Section 23(6) of the MPRDA proclaims that a mining right granted in terms of that act is subject to it and other relevant laws. So on a jurisprudential level, what we know from this judgment is this principle of complementarity. We can see that given effect on a practical level, where there is one law that regulates municipal planning and how it should apply to the MPRDA. There is no trump by the MPRDA. Instead, the two laws must complement each other. So your mere compliance with the MPRDA is insufficient. You still have to comply with the local government planning legislation. And Justice Shafter goes beyond, because he then references Section 23(6) of the MPRDA, which provides that a mining right granted in terms of that act is subject to the act and other relevant laws. So it's not just one law, it's other relevant laws. And the judgment by Justice Plaskett was also to the same effect. So what we contend here is that the MPRDA is not a substitute for IPILRA in relation to the land covered by IPILRA and the rights conferred by IPILRA to my clients. The two statutes are intended to operate alongside each other. Compliance with the MPRDA is not compliance with IPILRA. Compliance with IPILRA is a standalone compliance. We'll take the debate further in paragraph 122 of our heads of argument, where we show that the granting of a mining right under Section 23(6) is subject to any relevant law. So, for instance, what we know in Section 22 of the MPRDA is that there is an obligation when an application is submitted to provide for an environmental impact assessment. That environmental impact assessment report is not a report passed pursuant to the MPRDA. It is a report passed under the National Environmental Management Act, which is a different statute. But also closer to mining. Mining always has an impact on the usage of water. But it is not the MPRDA that would regulate the manner in which water rights are to be granted, but it is the National Water Act. Sometimes mining will impact on heritage sites, and it is not the MPRDA that would regulate the heritage sites, but it is the National Heritage Resources Act. So we can see this plethora of legislation that inevitably impacts on the decisions under Section 22 and Section 23, which we say the principle in Maxant is obviously correct, because you cannot allow the MPRDA to trump everything in its sight, because the MPRDA regulates mining. It does not regulate each and every sphere of life. So if in the course of the administration of the Act, it is necessary to comply with the National Water Act, there must be compliance with the National Water Act. If it is necessary to comply with the provisions of the National Environmental Management Act, there must be compliance with that. IPILRA fits within that scheme of complementarity of legislation. And we say that IPILRA, in fact, fits on a higher plane because it is a statute intended to give effect to a constitutional right of security, of tenure. So the contention that is made that the MPRDA would trump the operations of IPILRA has no foundation in the text of the MPRDA itself, but also it has no foundation in the legislative context in which the MPRDA operates, because the MPRDA was never intended to cover each and every conceivable fields. Even those fields that are closest to mining, like water and environment, are still regulated by statutes outside the parameters of the MPRDA. So we would submit with respect that on the first question around the complementarity, the answer is that it was never the intention, nor was it the effect of the MPRDA to cut through every statute that appears to impose constraints on the conduct of the government and the conduct of the mining companies. There is, and this is now the third point around the pillar, there is in fact no reason why persons such as my client should not consent, should not be entitled to say no to a mine. Why that is so is that historically, and I've taken your leadership through the history, my clients stood in a vulnerable position. The Constitution was meant to transform their position as decision makers in relation to the usage of their land. There is no reason, constitutionally speaking, why their agency must be overridden by a statute that is intended to regulate the MPRDA. What the government has argued is that what my clients want to do is to sterilize the mining operation. But there is no basis to the suggestion that my clients want to sterilize, because the mere fact that they want consent does not mean they want to sterilize. I've shown your leadership the problems with this specific application and the non-disclosures of the mining company in relation to, and the undisputed facts in relation to how this particular application was made, and the fact that there is in fact no alternative plan. My clients have said many times in the founding affidavit that the demand to be taken seriously does not amount to a sterilization of the exploitation of minerals. Because it is clear that if in the course of the bargain, and your leadership knows this from your days in the neighborhood, that if in the course of the bargain there are gives and takes, there are offers, there are counter offers, at a certain point in time, a consensus is reached, even where a strike begins on the basis that it's impossible to reach consensus. So the idea that a demand for consensus is equivalent to sterilization has no foundation on the evidence here, because of what has been specifically alleged by my client, that the problem with this specific way in which they have been consulted is that they've been kept in the dark about crucial information that would entitle them to make meaningful decisions about whether to allow mining or not. But the other reason why the sterilization argument does not work is because the government has the power under the Expropriation Act, because IPILRA specifically is subject to the Expropriation Act. And the government has not explained in the papers why it is not utilizing its expropriation power. So once you look at why are we in fact in this case, it's quite clear that the reason we are in this case is what my clients have said, which we have not been taken seriously about the information that is crucial to us. But also secondly, it's because the government has not bothered to make use of the power that it has to expropriate, because our IPILRA entitlements do not trump the expropriation legislation. So if the government seriously wanted to give effect to its Section 23 entitlements, it could utilize the expropriation provisions. And on the current facts, it has not explained why that is not open. So your leadership cannot, with respect, take seriously the argument that accuses my client of attempting to sterilize, because a demand for consensus is not equivalent to sterilization. But quite apart from consensus or no consensus, the government does not need my client's consensus to expropriate the land. It has the power that are conferred to it not only by the Constitution, but also by the statute itself. So on those two grounds, we can see that nothing really is to be made of the government's contention that this is an attempt at sterilization. And we also know the government's line in the papers, which is there is a broader benefit for the country. The difficulty with that is a factual one, is that we have explained in detail from the affidavit of John Paper that the alleged transformative benefits of the MPRDA are not borne out by the evidence. what mining actually produces for communities is not what is promised. So, neither of the two contentions by the government has any merit. There is no attempt at sterilization. And secondly, there is no clear case made out on these papers about the alleged benefits for the wider community that will eventuate. And talking about these alleged benefits, if this is truly to my client's interest, why should it be done without their consent? So, the last argument then around the PILRA is the references to the Bengwenyama judgment of the Constitutional Court. We have referred to the Bengwenyama judgment at length in our heads of argument. What I do want to add to what is contained in our heads of argument, and the arguments are all in page 56, paragraph 134. What is crucial about Bengwenyama is that it was not a case about a PILRA, and it was not a case about a dispute as to whether or not there should be mining in an area. It was a case where everybody agreed that there should be mining, but the dispute was about who should mine, whether it should be the company that was awarded the mining right by the government or a company that was sponsored by the community. So Bengwenyama does not undermine the substantive premise of my clients. Also because what it did not decide is whether under a PILRA consent is required. What it decided is that under the MPRDA, consultation is warranted. So it set the floor for consultation under the MPRDA, but it was not exhaustive about the obligations of the government in relation to other statutes. And I have already taken your ladyship to a survey of other legislation that are directly linked to mining operations but are not excluded purely because of the operation of the MPRDA. And we have referred to two judgments, paragraphs 135 and 138. I don't need to take your leadership through those judgments. They are both unreported judgments. One is pending at the Constitutional Court at the moment. But both of them are in the context of the MPRDA and IPILRA, where the starting premise of both judgments is that IPILRA requires its own provisions to be complied with. And the question that arose in both of those judgments is whether or not IPILRA was in fact complied with. And there was no argument, such as here, which was that actually we don't need to comply with IPILRA at all. So I will submit with respect that IPILRA remains in our statute books, notwithstanding the fact that it was intended to be a transitional provision. It is an important statute because it gives effect to a constitutional right. Its provisions build in consent and compliance with custom. Section 23, as construed both by the mine and the government, would undermine the provisions both of IPILRA as well as the provisions of custom. And in its text and its contextual setting, it is clear that the MPRDA has not ousted the provisions of IPILRA. And therefore, in a complementary fashion, mere compliance with the MPRDA does not oust compliance with IPILRA. And because there has been no compliance with IPILRA, we would be entitled to the declaratory orders that oblige the government not only to comply with the MPRDA, but to seek the consent of my clients as a matter of law. So could I then move on to the next substantive argument, which is the question of international law. The leadership will recall that we made two arguments about international law. The first argument we make is that international law is self-standing and confers substantive obligations on the state. We rely on Section 39, which deals with the interpretation of the Bill of Rights, and specifically subsection 2, when interpreting any legislation and when developing the common law or customary law, every court, tribunal or forum must promote the spirit, purport, and objects of the Bill of Rights. So that is the general provision about the Bill of Rights. 39D, when interpreting the Bill of Rights, a court or tribunal or forum must consider international law. We have located the claims that we are making firmly within the Bill of Rights because we are contending that this is a case about security of tenure that is provided for in Section 25(6). So firstly, when you engage in an interpretation about security of tenure, we contend that you have to promote the spirit, purport, and objects of the Bill of Rights in Section 39(2). And also secondly, we argue that you must give effect to South Africa's international obligations. International law is dealt with at pages 59 to 88 of our heads of argument. The general principle, again, we don't see any dispute by the government. The general principle of international law on questions of land usage in relation to land belonging to indigenous communities. What is, of course, remarkable in this case is that it is common ground that my clients are an indigenous community. An indigenous community as confirmed by our constitution, but an indigenous community in international law as well. So the principles that apply to indigenous communities in international law would guide the conduct of the government here. What are those principles? The principle of international law is what is called free, prior, and informed consent. And what does that mean? We've explained what it means from paragraphs 149 to 151. The words probably explain themselves, because free means that my clients should not be coerced. They must be free from obligations. And prior means that they should consent prior to the decision being made. And informed means they should have the necessary facts to enable them to exercise their consent. I've taken your leadership through the facts in this case, simply to illustrate how shadily my clients have been treated by the mining company, and how lacking in disclosure the application has been, and how the consequences of this shady treatment have resulted in an internal discord within the mining community, resulting in conflicts, intra-community conflicts. So the general principle in international law, when one deals with the deprivation of land rights in relation to indigenous community, is free, prior, and informed consent. In paragraph 154, we explain why our clients are indigenous communities in international law. And again, this is a principle that is not disputed at all. And from 156, we set out the various treaties that South Africa is obliged to follow. These are directly imported into our law because we have signed them. We have signed the Convention on the Elimination of All Forms of Racial Discrimination. We have signed the International Covenant on Economic, Social, and Cultural Rights. We have signed the ICCPR. We have signed the African Charter. The signature of South Africa to any of these treaties, international treaties, was not an act of charity. It was an imputation of international obligations into the domestic sphere. It meant that South Africa commits, not only internationally but locally, that it would comply with the principles that are set out in these treaties. Your leadership would have seen that in the heads of argument by the government, they have confined their response to the African Charter. But South Africa's obligations go beyond the African Charter. So you have to look at what are the principles that in international law, not foreign law, but in international law, what are the principles that would apply in relation to indigenous communities. So, we've dealt with in paragraphs 157 and 158 with the provisions of the Convention on the Elimination of All Forms of Racial Discrimination. And what has been said is that across the world, indigenous communities still face discrimination. What we know in the South African context is the most remarkable thing, because it mirrors precisely the position that was made, is that in the past, during the colonial government, during the apartheid government, clients such as mine had insecure tenure because of the failure to recognize indigenous systems of ownership of land, indigenous systems of access to land. And what internationally has been recognized is that those forms of discrimination continue to persist, even beyond the constitutional setup. And so, what the committee has then decided is two aspects. The first, which we deal with in paragraph 158, is that there should be no decisions directly relating to the rights, interests of indigenous communities taken without their informed consent. So the government is about to make a most crucial decision, which is to allow the mining company to come to my client's property. We've seen this, well, where they live, whether the property is owned by the government, but this is the property they occupy. We've seen this in paragraph 91. It is the entire area. They're about to allow mining trucks and excavators to go into that area and disrupt people's lives. In international law, they could only make that decision with informed consent of my clients. Those principles, your leadership, will not only take as guidance, but will take them as binding obligations, because we've signed those principles. The same position is taken by the ICESR. This is now the Covenant on Social and Cultural Rights. And we've dealt with this in paragraph 161 of our heads of argument, where the committee says that indigenous people have the right to act collectively to ensure respect for their right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions. And to give effect to that right, state parties should respect the principle of free, prior, and informed consent of indigenous people in all matters covered by their specific rights. And then the general comment continues that state parties should obtain free and informed prior consent when the preservation of their cultural resources, especially those associated with their way of life and cultural expression, are at risk. We know here, on the common cause facts, what this mining operation will do will be severely disruptive of the cultural life and disruptive of the resources of the community. And the point is, it may be that it is ultimately to the benefit of my clients that this should happen. But if it is to their benefit, why should it be done without their consent? So the same point is made by the third instrument, which is the ICCPR. PR. And they make the point we've referred to that in paragraph 162 at page 66 in the underlined portion, which says the committee considers that participation in the decision-making process must be effective, which requires not mere consultation, but free, prior, and informed consent of the members of the community. So, on the three instruments that apply on an international plane, we see that the notion of free, prior, and informed consent is embedded in these instruments. We know that this is indigenous land, and it is land that is held and ruled according to indigenous norms. And we know that the impact of the mining will be disruptive of the cultural life of this indigenous community. And the principle in international law is this can only happen with free, prior, and informed consent. That principle is not only an international principle, it is also an African principle. Because as we say from paragraph 163 up until page 169, the African Commission, which is the human rights arm of the African Union, has endorsed the principle. And at paragraph 166, this is how they put it in the judgment called Endorius. And we've referred to the judgment at footnote 126. The African Commission is of the view that any development or investment projects that would have a major impact within the Endorius territory, the state has a duty not only to consult with the community, but also to obtain their free, prior, and informed consent according to their customs and tradition. This is a crucial portion about the context of Africa, because although we see that in international law, they stop at free, prior, and informed consent, in the African context, free, prior, and informed consent is not enough. It must be free, prior, and informed consent in accordance with custom. And that is because everybody recognizes that indigenous communities in Africa had their lives disrupted by Europe. But the act of restoration requires the reimagination of their custom. And that is why in the African Commission context, it's been specifically held that free, prior, and informed consent must be in accordance with their custom. So, on the four instruments that regulate international law, we see embedded in those the notion of free, prior, and informed consent. In the African context, we see an adjunct to free, prior, and informed consent, which is compliance with custom. These principles I tried to outline are also principles reflective of our own constitutional scheme. The idea that people must consent before they can be overridden is itself a negation of what used to happen in the past, because colonial state after colonial state simply passed laws that overrode the rights of indigenous peoples in relation to the usage of their land. And so when one construes the MPRDA, one must always do it with this notion of never again, which is the underlying theme of the constitutional framework, and also with this notion of what current international law practices are. So we would submit with respect that we are firstly supported by the PILRA, we are supported by the framework of the Constitution, and we are supported finally by the provisions of international law. My lady, I've now finished the international law argument. I've got two more topics which will not take me more than 30 minutes. I wonder if it's not a convenient time to take the first adjournment.